Welcome to the latest interview in the series The Law's Two Bodies. The title and some of the inspiration from the project comes from Sir John Baker's book of the same name. Central to the book is the argument that the common law is almost universally regarded as a system of case law, increasingly supplemented by legislation, but this is only partly true. There is, he says, an extensive body of lawyers' law, which has a real existence outside the formal sources, but is seldom acknowledged or discussed, either by legal theorists or by legal historians. Our project asks the question, what is law? But pursues an answer in a fashion different from typical jurisprudential studies. It examines what legal practitioners do, how they regard law, to what extent they think about law in the abstract. The approach is ethnographic rather than philosophical or sociological. The aim is to build up a corpus of interviews with a variety of legal specialists concentrating on the issues outlined above. The interviews will involve a set of questions posed to all interviewees. At present, the purpose is to stimulate thought rather than to produce any publication. The aim is to create a series of interesting case studies rather than carefully representative sample of legal specialists. I'm John Hudson, and with me today I have Professor Hakeem Yusuf. Professor Hakeem Yusuf is Professor of Global Law at the University of Derby Law School. His books include Transitional Justice, Judicial Accountability and the Rule of Law, and Colonial and Post-Colonial Constitutionalism in the Commonwealth. Professor Yusuf is also a barrister and solicitor of the Supreme Court of Nigeria. In an earlier professional career, he worked as a law officer at the Attorney General's Chambers, Lagos, State Ministry of Justice, Nigeria, after a stint in private practice. In 2011, he served as Commissioner on the Truth Commission in Osun State, Nigeria. And he also consulted for non-governmental organisations like the Centre for Study of Violence and Reconciliation, South Africa. So, Hakeem, in your work, what proportion of time do you spend engaging with matters you describe as ones of law, as opposed to administrative or managerial or other tasks?
Maybe 2/3 of my time. And that goes beyond just the working hours, but also during the weekends, because I'm also a community leader, and you bear a double burden where you are an academic, you are known to be a lawyer, howbeit I make it clear in this side of the world that I am a barrister and solicitor in Nigeria, not here. Various members of my intersectional community bring legal matters to me, and I informally have to have something to say and then direct them. But in terms of my career as a legal academic, I think I would say fairly well that's over half of my time, and that is welcome, given that I have to keep up with developments, refresh my knowledge, think out of the box, engage with what I'll call socio-political, not just legal issues that affect people across the various interests that I have, whether that be thematic or actually geographical area. So I would say that the law takes a good deal of my waking moments,
right,
as it were. So it's more than half.
You said part of the time being consumed is keeping up.
Yes.
From where do you get your legal knowledge, both scholarly but also the sort of practical questions you are being asked within the community leadership role?
Yes, that's an interesting one. So I have to keep up with government policies on immigration, for instance, and so I do check what is happening on the media to track legal policy developments, and it's not just the BBC, but also international media, and so the radio is one of them. whenever I drive a lot, whenever I'm driving around, but also the newspapers. And how be it that you get a hackneyed sort of reportage, especially from newspapers beyond, media beyond the West, on reportage of legal issues. At least it gives me an awareness of developments and the need to look for what has cropped up. So that is one. And of course, the people bringing the issues are also a veritable source of information as to what developments there have been. And that leads me back to the books, leads me back to, say, for instance, regarding immigration law, the Home Office and the government platforms regarding policy, as it were. So, yeah, it's not the conventional legal sources in the first place, but I would say news outlets lead me back, and also people with the different issues that they raise, sometimes just government websites.
I'm interested in this input from questions from people, practical questions. Are you ever getting questions which are not, help me, I've got a legal issue, can you help me with it? But questions about changes to law, that specific issue. This has been changed, or this may be changed, how does it affect me?
Absolutely. So, for instance, during the Brexit debate, I realized that people were very anxious in the communities I belong to, and that's a fairly large community. It's a community not based just on ethnicity, but also on sometimes religion, sometimes culture, and so there are a wide spectrum. And relating to Brexit, I had to come to a determination based specifically on anxieties in the communities where I offer informal leadership of migrants, as it were, Africans and people from the Middle East, who hold non-British nationality. I had to organize a seminar in a cultural center on Brexit and you, in order to break it down as to what this meant and what the requirements will be for continuing stay for those with European nationality in the UK. So yes, I do get that sort of challenge, and I have to go back away to see how I can informally advise. It ends up, most cases, with directing people to the right formal legal experts who people can trust, but they would assume in the first place that I will take up these issues.
So there's a sort of interesting cycle where someone comes to you with a legal, personal but legal question, which may or may not be clearly formulated legally. You are getting input, in many ways you're saying, from non-legal sources through your legally trained and practicing an academic mind, and then you are feeding back into them the information, in some ways the non-legal information that you have put the law into, and then feeding it back to them for their legal need, but presumably not in specialist legal terms.
Oh, not in specialist, okay. Absolutely not in specialist legal terms. In fact, now there you reminded me, one of the ways that cycle works is that I'm privileged, of course, to have either students who over the years have taught in practice, or friends who, unlike me, are in practice here, the solicitors, usually solicitors, and I feed some of that. I save them costs by feeding back on developments or questions I need information on, and I take that back. In some cases, it then requires me connecting them. But in many cases, it means that the issues can be informally resolved for them through those channels. Yes, so you're right.
I mean, the next question takes us on to the heart of the Baker idea of the law's two bodies, and this informal body of law, which he is saying is a shared body in his historical circumstance amongst the senior members of the legal profession, be they judiciary, be they barristers. But it sounds to me as if you're working within a legal community in that sense where there's a shared exchange of knowledge, working in a sense across the barriers or across what might be seen as the confines of law. Is that a reasonable way of seeing the body within which you're working?
Yes, so I think the two bodies, the concept of the two bodies, a formal and an informal one, captures what I do. So most of what I've described have to do with the informal one. And for me, that is more as a vocational matter and as a practical matter. That is for me probably more important because so the law is imbued with power, and for people who are at certain levels of society, the informal mechanisms or the informal route of being able to link them up with the law plays a very important role. They don't just know where to go. So yeah, that is one level. There is the formal level, of course. There is the formal level of interaction as an academic. The formal level of interaction where I'm dealing with colleagues and sharing knowledge in spaces like the one we'll have in lectures, in seminars, and I'm dealing with my students, research students, learning about spaces sometimes beyond the law. And when I say spaces beyond the law, of course, law organizes spaces, but there are spaces beyond the law, especially in the global south, where the life of the formal life of law is one that is more abstract than real, is one that is distant, is one that represents a level of disengagement, of abstraction that they don't engage with in the active sense. But they do have their own conceptions of law. So I benefit from that also. That helps me with the informal engagement in communities. But the two bodies conceiving of law as a formal and informal institution, as it were, plays out in my everyday engagements in ways that sometimes blurs the lines because the one leads to the other. The informal requires me being able to move back to the formal and bring back that, and the informal one and the formal one takes me sometimes, depending on who my interlocutor is, into the realm of the informal.
Sorry, this is taking you away from the questions I warned you were coming, but it follows from what you're saying. Do you think your position in this sort of mediating between the formal and the informal is different because you are now a legal academic, having been a legal practitioner? Would it be different if you were having this mediating role as a practitioner as opposed to someone slightly distanced from practice by being an academic?
Absolutely. It's really served that I've been a practitioner for almost a decade before I became a legal academic, because it then means that I know the terrain, the challenges, howbeit that my practice is not being UK based, but I'm actually dealing with people who were the subjects in the terrain that I'm used to. But the privilege of being an academic and the status that confers brings a double-edged thing. It brings more burdens because you're a professor of law. The ordinary person thinks that your academic practice or skills or experience or knowledge matches that, and I have to step back and make clear that I am an academic. Yes, that serves me well when I'm dealing with consultancy for international organizations. But at the level of the informal, it also brings a burden on things that I don't even have an answer for, because there's only so much of the different fields of law that I have a handle on. Albeit that I'm also privileged that I I earned my degree and practice in a jurisdiction where you're just a lawyer, and you are a lawyer covering everything. So that really has helped, and it would be different if I had been just one or the other, no matter how versatile.
And I mean, clearly you've practiced in multiple systems. What are the big advantages of that for you? Not so much in terms of being able to contribute different expertise, but the sort of reflective element of it. That does it make you think about law in different ways and engage with people and their legal questions in different ways?
Absolutely. So talking about my work regarding working with the U.S. Department of Justice and engagement with U.S. law, it makes, even though it has as its root a common law heritage, show as against the law and the legal systems in Europe, say in Gibraltar, we are also engaged, or even in Africa, in Commonwealth Africa, gives actually reflecting on it gives me an opportunity to understand that the law is, as an institution, is not at all a neutral one. It's one that, like all other human institutions, that is created, that is reflective, or should be reflective in different ways of the history, of the culture, of the political, socio-political, and even economic preferences of people in society. And it's so poignant, actually, that I also have the privilege of studying in Glasgow and teaching within the Scottish legal system, and I can see similarities in terms of a conception of what law does, but there can be vast differences also that makes you think that the law is a living body that also breathes what we breathe, where we are, and is fed and develops on what we are fed and develop on. So the law has multiple lives for me.
So how far are you interested in the law, in law in the abstract, in jurisprudential questions, or the sort of, in a sense, more practical philosophical questions of law?
So I would say this. I was supervised for my PhD by a leading legal theorist, and I told them from the start, I'm not aspiring to be a legal theorist. I did teach jurisprudence, but I prefer it as law and society. And for me, the questions of the abstract are sometimes an aspect of law that I have little patience with, given the more alive challenges, more practical, pragmatic issues that have to be dealt with in the context of the global south that takes a good deal of my attention. But whatever system of law we are talking about or think about, there is a need to understand the jurisprudential foundations and the understandings of what should constitute value in society that the system of law is meant to espouse. So yes, broadly speaking, it's something I look out, the abstract forms or issues around law is one that I look out for, but I don't dwell on them too much, because I'm just able to abstract the most basic principles and run with it to resolve everyday pragmatic challenges and issues.
In a way, linked to that is the question of whether you're interested in the history of law, simply for its own sake because it's interesting, or whether it has any practical engagement with what you do.
I think that in the last 10 years, thereabout, I have been drawn a lot more into the history, the importance of the history of law. And for its own sake, it's so profoundly interesting to me and so enriching, because I just see in it a mirroring of what issues we think are just new today. So to that extent, even for that alone, it has huge value for me. But that outflow of seeing a replication of what we are having to deal with in different ways, down to the specific issues, nuances, responses, down to the same set of players, makes it something that I think has not been given its due place in legal academia and legal training. And I was saying yesterday to colleagues that if I have my way, legal history should be a compulsory aspect of the training of lawyers in any legal system or legal education. It should not be something you happen on. So for me, both ways, the utility of it in solving or addressing not just the learnings. I mean, there are solutions there, right, for the challenges we face now, but the profound way in which it sometimes shows you that really nothing changes. The dressing, the book cover changes, but the book content doesn't change in terms of human societies. And for me, legal history should be a cardinal reference point in addressing or understanding legal problems and preferring solutions. So yeah.
So I mean, that very much fits with your answer to the previous question on abstraction, where you said, yes, I'm very much interested in reflection rather than a pure abstraction, and that history is part of that reflection, promotes reflection.
Absolutely. It not just promotes reflection, to be honest. In some ways, it provides answers to solutions that we are seeking through a process of abstraction. Because whether you look at English legal history, you look at empire legal history, you find that the construction of society, the application of law there has shaped our continuing institutions, the power structures, the economic, political, social arrangements that we have. And some of the time we proceed like law is neutral, and that the values ostensibly espoused or attached or ascribed to law and its institutions as constituted are actually for justice. And you find the negative when you scratch the surface historically, as it were. So yes, and I would rather engage with that a lot than the philosophy of law, as it were. I would rather engage with how the law complex or the law institution was constructed by looking at history, what the society was, what the issues were as they were captured then, helps me to understand the challenges and the possible ways to address them. And that leads in different directions, leads into politics, leads into anthropology sometimes, and of course, even just general history, apart from legal history.
Yeah. The last question seems slightly different from the others, but actually it's very closely connected with them, which is, how do you see the role or the interconnection of law and emotion? Notably, whether the function of law is to exclude emotion, to control emotion, and this also clearly comes back to the sort of practical approaches that you have within your community leadership work. How do these things fit together?
Now, I think the touchstone of this for me is the conception that law is neutral, and that the interpreters of law, whether as an academic or even a judicial officer or someone who has the duty or job to apply law, should be shorn of emotions to achieve justice, a sort of neutrality. I think it's like hindsight, it's a lie. Emotion should be a part of law. Law itself is constructed by certain emotions. If emotions mean, and that's probably where there's an issue, what do we mean by emotions? Yeah. If emotions mean our reactions, our responses to realities of living and life, then law does take up or does reflect our emotions. And for me, as a lawyer, I do get sometimes caught in the web of having to deal with my emotions and the emotions of people, especially in the informal, setting that I belong to. And I don't think that law is necessarily jeopardized by the recognition of emotions. If anything, it is the presence of emotions, of sympathy, of empathy, of shared understanding of what people, groups or individuals are going through that actually excites me or drives me to various themes and work that I produce in law. So to give an example, when you have the opportunity that I had of practically getting university education free in Nigeria that I did for my first degree, you then have to pay back with a year of national service where you are taken out away from where you are to another region of the country, and usually to probably a rural place where there is a lack of expert manpower, lawyers, doctors, teachers, engineers. And I did my national service where Shell produces oil. Ogoni land is part of where I did my national service. And I saw rivers that had turned into literally oil rivers, with people who were riverine people not being able to fish or get fish, with their fish being more expensive than people who were in the hinterland. And that stayed with me. It was a real shock because I come from a coastal area where the sea is the sea. And there were people who I was taking to the seaside where in the morning I saw fishermen going out and their families had accompanied them before they set out in their boats, hugging them and everything. And my friend who comes from the area said, "I brought you here to see. These are people going fishing. What do you think is happening?" I said, "Their family are here. It's a little strange. Their wives, their kids." And he said, "It's because they may never come back. Every morning they go, they may get into the waters in Cameroon and they get imprisoned. There is nothing on the sea that says this is Cameroonian or Nigerian waters. They have to go so far out into the sea to catch small fish." And that really stayed with me because about 8 years later, when I did come, or 9 years later, when I did come for further study, and it then meant I was doing a human rights program at the University of Ulster, I had to write paper in my advanced human rights course, and it had to be a topic of my choosing, and I came up with oil on troubled waters. And I think the emotion that went into writing that paper caught the eye of at least one university lecturer in the United States, and he wrote me an email within a year of its publication. And he said, "I saw in that paper," he said, "congratulations on writing that paper. I saw something I had not seen in works on this issue there, and I use it now to teach my students, because it showed me that you had been there, and the vivid description of the suffering and the issues there on the incongruent powers is something that is missing when we just talk about these issues." So for me, emotions play a big part. When somebody is afraid that they may be deported because they have an appeal pending in the Home Office, and they are a breadwinner and all of that, emotions come in. I have to deal with that to get a clear head out and also deal with it, get the issues. So yes, I think that law is enriched with emotions, but law should not be driven by emotions. I think that is where the line is. The law is the law, but it's not true in my understanding that it was constructed by some emotionless or emotionless being or group of people who themselves are not driven by certain values. And values have an intermix of emotion, faith, belief, worldview, cosmology, which are all fine. Law is a living institution to express how we want society to be organized. And if it's going to speak to us, it must be constructed with, sometimes managed by, emotions, as it were.
Thank you. That's been fascinating. Fantastic. Thank you very much.
Thank you very much.